Hi, everyone. Thank you for joining us today for Constangy's webinar, DEI for the Savvy Employer, Navigating Challenges and Maximizing Opportunities. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time to answer your questions. This program is approved for Sherman HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Cara and Punam.
Great. Thank you so much, Victoria. Welcome, everyone. We're very excited to present on DEI today. My name is Cara Crotty, along with Punam. I'm a co-chair of Constangy's DEI practice group. I am located in our Columbia, South Carolina office, and I am also chair of the firm's Affirmative Action OFCCP compliance practice group. Punam, take it from here.
Sure. Hey, everyone. So glad to be here. A little bit about myself. I'm actually a business immigration attorney out of our Boston office. And over the course of my 20 years of experience, I kind of embarked on DEI sort of organically while I was representing clients who hired diverse talent. In immigration, I used to coin immigration as the sleepy corner of the legal field. But today it's one of the top election issues, and DEI is quite similar. When I started this work over a decade ago, I don't even believe we coined it DEI, but we talked about the same elements, and the focus and goal has always been to improve workplace culture, which essentially is the same goal today. So why are DEI efforts today met with such resistance and negative stereotypes? Well, I think much like immigration, it's been highly polarized, politicized. And I think last year's Supreme Court ruling, the Students for Fair Admission, also added some uncertainty and legal challenges, causing many private employers to kind of scale back, rethink their DE&I initiatives. And I'm guessing you're here today because you understand that at its core, it's pretty simple. The work that we do. It's about when you come to work, if you feel seen and heard and supported, if you feel like you can be yourself, you're likely to be more productive, more empathetic to your coworkers, more creative, more innovative. All of these qualities lead to better outcomes in workplaces. So today, we're going to talk about these things and really at a practical level. First, we're going to dispel some myths and stereotypes that have perpetuated over the last couple of years. We'll also go over what you can or cannot do, or what you really need to think about before doing. And then finally, some practical, simple strategies, best practices that are legally sound today. But let me just start by saying that DEI is not a one-size-fits-all approach. So some of what we're going to say might work for some employers, and that's perfectly fine. And maybe it won't work for you, for other employers. But as you listen today, I tell my clients a couple of things. First, you can't fix what you can't see. So each of us, because of our differences, view the world with our own unique lenses. And DEI work often requires us to broaden that perspective and sometimes even adopt an entirely new one. That's why it's essential, I think, not to undertake this work alone. So I'm glad you're here with us and collectively working with folks in your organization. And second, just remember, the goal here is progress, not perfection. This work takes intentionality, it takes time and patience, especially in this ever-changing legal and political landscape. So let's dive in. I'm going to go through a couple of stereotypes that we believe we're going to try to dispel some of these stereotypes. So DEI often equals, folks believe it means reverse discrimination. The fact of the matter is DEI is not law, and it doesn't really direct people to do or act in a discriminatory manner. We all know that. It's also not affirmative action. That's a whole body of law that Cara here is an expert in. but rather what DEI really is, and what I've practiced in so many years, is its principles and its values that define and inform processes that improve workplace culture. Like I said, it's not a one size fits all. So DEI represents each employer's own set of values, and how it's defined and implemented are often unique to a particular workplace or employer. But if we deconstruct these words, they're also quite simple. Diversity, for example, is really just the presence of differences in a given setting. And we all know that differences that you have in relation to others in any given setting can make you feel a certain way. It could sometimes make you feel anxious or fearful, or maybe empowered or motivated. I am an Indian American, and growing up, I actually was aware of my differences in many different settings, whether it was school, workplace, friend circles, cliques. But I found that when I found shared interests or commonalities with those who were different than me, where I felt seen, heard, and they did for me, we all felt a little less different, which led me to feel more relaxed and be myself. And that's what equity and inclusion really are about. It's ways to operationalize what we all kind of do in our personal lives with friends and settings that we find ourselves in. Equity often is just ensuring fair treatment, access. Inclusion, which I think is the most important out of the three, really is the actions that you take to build fair processes and practices, so that people who are different, they're not limited, and we don't predict their outcomes or their ability to succeed. I often tell this story. It's kind of what got me into this type of work, which was in the mid 2000s. I was representing a large university client here in Boston, and they had hired a bunch of H-1B workers from India. A great majority of them were from India. And while the goal wasn't to increase diversity within that organization, it was really to address a project need that they had. They did find themselves with employees who had different cultural backgrounds, work style, languages, and something management really didn't think about too much. The job market in IT here was booming. So about 6 months to a year after they brought on about 30, 40 of these folks, they started to find that these H-1B employees were changing jobs. The university was frustrated. They spent a lot of money, time, investment, training, legal costs. And so they came to me and said, what can we do? Can we, as Immigration Council, can we restrict them from going somewhere else? And obviously the answer was no. So we sat down and we talked to HR. We talked to some of the employees. And what we learned was they felt isolated, lonely. They felt unsupported. They loved the work that they were doing. They were fine with the pay. They just didn't feel like on a day-to-day basis they were included in conversations or activities, lunch plans. And at the same time this was going on, we were trying to brainstorm what we could do. HR approached me and she asked me, well, a bunch of employees want to get a conference room together and celebrate this Indian holiday. I think it's called Diwali. It's a major holiday. It's a festival of lights. And so I said, why don't you let them get a larger conference room and invite everyone, plan something that's inclusive, and that way some of the other 120, 30 IT employees can maybe connect with them. So they did. And, it turned out that many of these employees brought in food and dressed up in the garb, and they sang, they put together a presentation. It was a huge success. Both groups of employees connected. They felt like they could relate to one another. But over time, these efforts, in fact, 10 years later, I was actually invited to go back to one of their recent Diwali events. And it was great to see. And one thing that the HR person who's still there said, they've had measurable impact by just this event. They've done other things. But what they found was managers reported better productivity, but more importantly, the retention rate for H-1B employees increased. And I know this because many H-1B employees come here temporarily and they want a green card. And many of them are still working there today. So it just shows that sometimes DEI efforts can be just that simple. All right, I digress. Next stereotype, diversity. Many folks hear the term diversity and they think it's only about race. Obviously, that's not true. Diversity is all sorts of things, protected classes like sex, age, national origin, sexual orientation, but it's also a host of other characteristics from socioeconomics, even personality traits, neurodiversity. So just remember, it's just the differences between employees or people. Another stereotype that I hear all the time is DEI policies lead to DEI hires, meaning that these policies cause employers not to hire the best candidate. The fact is that it is unlawful for employers to make employment decisions based on race or gender or any other protected class characteristic. What I see is lawful DEI policies, as Cara will discuss shortly, focus not on the end result, but more on expanding opportunities and candidate, for example, like expanding candidate pools by expanding recruitment, adjusting job postings, training, hiring managers or recruiters on how to conduct interviews that align with your organization's DEI principles. So these type of DEI policies are not outcome or goal oriented, but what they do is they ensure fair processes, consistent processes that everyone can expect and adhere to. Another stereotype along the same lines are that diversity goals are quotas or they create preferences, meaning you have a goal that you're going to hire 10% of women and everyone just hires women. And it's a tricky area. And again, Cara's going to get into this, but I look at it like, for example, like a gaming company that sells video games, where a majority of its customers are young boys, and they say they want to increase their customer base by 30% over the next 2 years to more females. Is that unlawful? No, it's something that they're working towards, and they're not saying that they prefer to sell only to females. Rather, they're looking to expand their market strategies to expand to a market share that they don't necessarily have. It's similar with employers who want to expand their pool of employees by X% to a specific, say, gender or race over a prescribed period of time. It's not unlawful if the manner in the manner in which they do it doesn't have a prescribed end result, if you will. And Cara will touch on this in more detail in a few minutes. It is kind of tricky. What I usually say is aspirational goals that companies working towards or aspiring towards are generally lawful. Another stereotype that we're seeing a lot of legal challenges in recent years is DEI training. There's a notion that DEI training is discriminatory on its face or creates a hostile environment, or that it's only about critical race theory or something like that. And we know that that's not true. In fact, for private employers, DEI training, whether it's mandatory or optional, is not unlawful, even in situations where employees disagree with the content of it or they're made uncomfortable by the issues raised. We do know that public institutions in certain states, I think there's about 15 or so, have restricted some types of DEI training if the public institution receives funding. So this includes universities in these states. So you have to be mindful of that if you are in one of those states and you want to conduct DEI training. But for the vast majority of private employers, they're not impacted by these laws. So the trend right now legally, and I'll share two cases that really, I think, highlight that DEI training, isn't per se discriminatory or unlawful. One such case is the Honeywell case. This was a case where an engineer, Charles Vavra, was fired after he was asked to take unconscious bias training, which was mandatory for all employees. And he refused to take it over a long period of time because he felt that the training was discriminatory. Well, the court ruled that the case was meritless because he never actually watched the training to determine whether it was discriminatory or not. And I find this case interesting because the trial court was an Obama judge appointee who dismissed the case. The circuit was an all-Trump appointee court, and they also agreed here. And in fact, the EEOC filed an amicus brief in this case where they also indicated and stated that anti-discrimination trainings, including unconscious bias training, are not per se discriminatory, and they serve a vital measure to prevent or remediate workplace discrimination. So despite, there's a couple of other cases that I can get into, but despite these rulings, what I certainly suggest is employers carefully review the content of their DEI training, including materials and particularly vendors that you hire who provide these. You want to make sure that the goals of these trainings are supported and the materials are accurate and they don't unnecessarily alienate one set of employees against another or alienate one set of employees, period. You may also want to consider whether you want to make these trainings mandatory or optional. Even though mandatory training isn't unlawful, it may be easier to defend. The last stereotype that I'll discuss today is similar to training is DEI policy. Just because you have DEI policy and you get sued doesn't mean you've engaged in unlawful activities like reverse discrimination. One such case, and actually this was one of the first cases to test this legal theory of corporate diversity practices and reverse discrimination. It's the Gannat case. Cara wrote a blog piece that's on our website if you want to read the details of this case, but it's quite interesting because it was a group of plaintiffs that sued a newspaper publisher where they said that the company's diversity policies, which really were, their policy or their statement was that they expressed a commitment to having their staff demographics reflect the communities that it actually serves or publishes or buys their products. And here the court dismissed the case, holding that the diversity policy alone did not establish that these white employees were treated any differently, since the policy itself didn't describe any specific goals. Again, it was just aspirational. And the plaintiffs here didn't really provide sufficient facts to support these claims. Here, the judge did grant these plaintiffs an opportunity to amend their complaints, which they have. And we'll see where this case goes because it is ongoing. But the key takeaway here really is the mere existence of a diversity policy is not sufficient to establish discrimination or any discriminatory motive. So I'll end just by saying it's not easy to combat negative DEI stereotypes today because there's a lot of disinformation, misinformation out there. But for me, it's going back to the basic principle for DEI and acknowledging and recognizing our workplaces have employees who are different. There's going to be differences. And while we can't solve the world's inequities, but what we can put in place is fair and equitable DEI practices as best as we can to support our employees so they can thrive. And I think if you can do that, that's a win. Anyway, I'm going to turn this over to Cara. Now that we've dispelled some of these DEI myths or stereotypes, what can employers do? Or more importantly, what should they stay away from doing, particularly when it comes to, I guess, quotas? That's the one that always confuses me.
Yeah. Thanks, Punam. So these next few slides come from questions that I've received a lot from clients. So over the years, that it's not all recent development since the Supreme Court's decision, as you mentioned last summer, but questions that have come up periodically, routinely, but I think have resurfaced significantly since last year's Supreme Court decision. So I thought these would be some good uh, employment practices to walk through with you. We'll give you, and we kind of juxtapose that these are okay. These might be more problematic, and you want to tread carefully for some of these. And Puna mentioned quotas. So quotas are where an employer says we are going to hire X% or X number of people from a certain demographic group. Set-asides are where an employer says we might have 10 openings, but one of them is going to go to a person of color or some other, or based on race or gender or some other protected characteristic. And or a determinative factor is similar, where we're making an employment decision based on a protected characteristic. So those are generally going to be problematic for an employer. Title VII is clear that we can't make employment decisions based on race or gender or color, national origin, religion, sexual orientation, or gender identity. So any decision regarding any type of employment practice, whether it's a promotion or hiring or termination, or even very likely it would include other terms and conditions of employment, like a transfer or benefits or those types of things. So we want to make sure we're not making any employment decisions based on a protected characteristic. So as long as we are providing equal employment opportunities to everyone, we shouldn't have an issue with respect to this type of practice. And one kind of rule of thumb that I suggest to clients when they're thinking about implementing a new practice or initiative of some kind that might seem to take into account a protected characteristic, I suggest replacing that word with white, and see how it sounds, and if it makes you cringe, because it's obviously would be unlawful, then you could very well have a problem as well. So goals are interesting. We've seen a lot of employers developing diversity goals, especially since 2020. And as I mentioned at the beginning, I represent federal contractors. I do a lot of affirmative action, compliance, advice and counsel, help contractors develop their affirmative action plans. Those are all still lawful. And I think non-federal contractors can take a page from the federal contractors rule book when it comes to developing goals, because it's all about really evaluating your existing workforce to see where do we have areas of underrepresentation. So when federal contractors set goals, they're basing them on specific objective criteria. They're not just pulling out of a number out of the air and saying, hey, we think our workforce should look like this. So if you are going to set aspirational goals, you want to make sure they're framed around some objective, realistic numbers. We also don't want to commit to attain a certain level of representation or to increase our workforce a certain percentage by a specific date. Again, without ensuring that it would be feasible based on our expected attrition and number of openings and that type of thing. It just sets you up for potential failure if your goals are not reasonable and are not likely to be attainable based on the numbers that you're using. You set unrealistic goals, you're just going to likely be unable to achieve them. But also what we've seen challenged a lot in the past couple of years when it comes to employers' stated DEI goals is around the employers, the verbiage they use when they're describing their goals and saying, we will do this. We want to achieve this goal by this date. It raises an inference, or at least this is the argument, that it's raising an inference that you will be making employment decisions in order to achieve that goal. So you want to avoid creating that appearance. We also want to make sure that it's understood our goals are going to be gradual and incremental over time. We can't change the demographics of our workforce on a dime. It's going to be based on the number of openings that we have, the amount of attrition. We also have to remember that people within our workforce are going to be moving up. And so that will change the demographics of both the group they're leaving as well as the group that they are joining. So that can affect our workforce representation over time. So goals can definitely be tricky if you're setting aspirational DEI goals. But I recommend taking a look at how federal contractors do it, because I think that will be easily defensible, and as well as an appropriate way to look at how you're measuring your workforce and your expectations. Another question that comes up a lot are incentives, providing incentives for, especially our executives, for attaining diversity metrics. There's nothing per se unlawful about it, but the problem can arise because it can create the perception that we're motivated to make hiring decisions based on protected characteristics, right? People want to if their bonus is going to be tied to achieving a diversity goal, then they're probably going to achieve it, and they might not be able to do it organically. So the argument, when incentives are in place, the challenges we've seen is that it doesn't force people to make employment decisions based on protected characteristics, but it's kind of encouraging them to do so. So it can put the employer in a difficult position defending employment decisions that are made. Showing the legitimate non-discriminatory factors where you might not otherwise have those types of challenges. So we recommend, instead of incentivizing by bonus or other means, the attainment of diversity metrics, just make sure we're evaluating our managers on their commitment to our principles on equal employment opportunity and DEI and equitable treatment of employees. And we also want to make sure that managers understand how to talk about our DEI policies and our goals to avoid creating a misperception about what the employer's policies and practices really are. I have, from reading many of the challenges that we've seen filed in the past couple years, there have been allegations that, well, the manager said we can't hire any more white men or something to that effect, right? And so you're wondering, of course, these are just the allegations in the complaint, and the employer hasn't had the opportunity to respond to them yet. But so you're left with, well, did the manager even say that? It might not be an accurate reflection of what was actually said. But then two, if the manager did say that, where was it coming from? Because it's unlikely that that was the express instruction given to the manager. So what was going on in that workplace where that's the inference that the person took away from the directions? So be careful about how we communicate our goals with managers to make sure they understand that we are always going to make our employment decisions based on most qualified characteristics. Diverse slate policies are another interesting DEI practice, and they've evolved over the years, but I think a common one that I've seen or heard about is where an employer will say, before we send our hiring slate of candidates to the hiring manager, the decision maker, we want to make sure that at least X percentage are diverse candidates, female or people of color, and so then TA will work to make sure those candidates, whatever the slate is, meets those certain demographic requirements. Now, sometimes that can happen organically, and that's wonderful, but oftentimes it doesn't work out that way. And so the recruiter is put in a position where they're having to move people forward in the process, or trying to find people to move forward based on a protected characteristics. And the EEOC is clear in its guidance that culling candidates based on race is not allowed, or gender. So that's in effect what what would be happening in those circumstances. So I recommend, instead of saying our slate of candidates must look like this or have this percentage of representation, instead of doing that, before we even start looking at our applicants and evaluating them, let's look and see if the pool that has applied is sufficiently diverse. Have we done a good job with our recruitment efforts in recruiting a diverse pool of candidates from which to choose? So that's okay, because we're not looking at individuals' demographics. We're just looking at the overall pool, and we compare that to where we're located, the type of job, and the demographics that we would generally expect to see for that type of position, given those factors. And if our pool is sufficiently diverse, then we go ahead and apply our normal non-discriminatory selection process. If maybe our pool is lacking, if we think it could be more diverse based on the availability demographics, then we do more recruiting before we start our selection process. But that way, we're allowing the talent acquisition to develop a diverse pool of candidates, but we're not kind of pigeonholing people in the process and moving them forward because of their race or gender. Diverse hiring panels, I'm a huge fan of these. I think it's great to make sure that the individuals involved in making a hiring decision come from different backgrounds and have different representation and demographics. Where I have a little pause is if we mandate them all the time with no exceptions, and then it feels like we're fitting a round peg in a square hole to find a diverse member of management that might not have any background or knowledge in the job that we're making a decision for. I think it's best to have our general principle that we will strive to have a diverse hiring panel, but not make it mandatory in every single circumstance where it might not be feasible. Recruitment practices, I think this is the huge part for DEI, because it really all comes down, when it's talking about diversity, it comes down to your recruitment practices. And federal contractors have been doing this for years. They're required to affirmatively recruit females and minorities to their workforce. And that's really the whole theory behind affirmative action for federal contractors. It's that if you are going out there and recruiting more candidates, more diverse candidates to your applicant pool, then gradually over time, through the application of your neutral, non-discriminatory selection process, your workforce is going to become more diverse. So all employers can be doing that same thing. The only kind of caveat or recommendation here is don't rely exclusively on those diverse or inclusive recruitment sources. I think you want to continue to use a wide variety of recruitment sources, including those for diverse candidates. And this kind of goes back to, you might remember cases, they haven't come up so much anymore, but we used to hear about the word of mouth recruitment cases where an employer only relied on its employees to refer candidates for employment. And in those situations, it just so happened that their workforce was predominantly white men. And they, of course, were referring their friends who were white men. And so kind of the lack of any other type of recruitment effort was found to be a discriminatory recruitment process. So we just want to make sure our recruitment processes and practices remain open and are inclusive. Training, mentorships, fellowships, scholarships, internships. A lot of these have been in the news the past couple of years, where there have been challenges. And I think many of the challenges have arisen where an criteria for eligibility was being a person of color or some other demographic. Many of those cases have either settled because the criteria were modified, or some have been dismissed, though, on grounds of lack of standing. The person bringing the challenge did not show that they had applied for the program, so they couldn't show they'd suffered an injury. But I think the lesson learned here is that we don't want to limit opportunities based on race or gender for these type of employment opportunities. We need to make sure they're open to everyone, regardless of those factors. What we can do, and the changes that we've seen organizations making, is instead of focusing on race or gender, focus on what you're really trying to solve for, which typically is we want to help people who are underprivileged or maybe don't have the same resources as others in their upbringing, in their life. So focus on socioeconomic factors. And I think that will probably get them better results in the long run, as well as avoid these types of challenges. A lot of employers have employee resource groups or affinity groups, business resource groups. They're called a lot of different things. And they've been around for decades now. We kind of saw a resurgence of them in the past couple of years. And these are fine for employers to develop in their workforce. We do recommend that that an employer not limit participation in an ERG based on protected characteristics. So for example, if you have an LGBTQ resource group, allow anyone that's interested to participate in that, and don't limit it to individuals just from that protected group. So again, just making sure they're open and inclusive. And it's always a good practice for employee resource groups to ensure that the company is providing oversight and governance to ensure consistency and that they're meeting community standards. It's always a best practice for those. And then we also want to make sure we're monitoring our internal DEI communications to employees, whether it's in our training materials, our newsletters, any kind of publications, as well as, like I mentioned before, how our managers and executives are talking about DEI and EEO. We don't generally want to single out any kind of specific demographic group in our communications to employees. If we're setting a diversity goal, that's fine, but we typically recommend you stay away from verbiage like, oh, we have a problem in this area, or this is where we want to focus on, because it creates the impression or potential perspective that we're not worried about everybody, right? But we want to be inclusive. Obviously, when we have openings, we don't want to indicate a preference for a certain race or gender. So when we're communicating with our employees, we want to make sure we're focusing on equity and fairness and reiterating our core policies around EEO and non-harassment, non-retaliation, and just striving to make sure all employees feel welcome and valued. I'm going to turn it back over to Punam. We're going to talk about some additional practical strategies for employers when it comes to DEI initiatives and programs.
Sure. And so to continue on communications, policy statements, we all saw, in 2020, May 2020, after the tragic murder of George Floyd, it prompted many employers to hastily publish statements on their website, social media. They often on their 10K or annual reports, even during board meetings or social or general internal and external meetings. But then they didn't really revisit it or do anything about it. Or perhaps they did, but didn't really think too much about it. And now you fast forward and we have activists on both sides. But, like Robbie Starbuck and others who have started to expose some of these employer statements. And so as quickly as some of these companies put them up, now they're taking them down. And that, I think, too, carries some potential risks that we likely will probably see some legal challenges on. So be careful about that. But we also discussed that these statements and policies by themselves are not illegal, and they don't inherently serve as evidence of discrimination. right? I talked about a case earlier, and there's a handful of those. But nonetheless, it's really important for organizations to review their public and internal DEI statements, like Cara just carefully went through. So I'm not going to repeat much of that, but I always focus on, look at your company's values and principles and make sure that those statements that you put up on websites or externally, whether it's marketing or just feel-good statements or mission statements, that they're backed up by what you're actually doing, by data, that you're not over-promising and under-delivering. And just, I think it's always good to maybe on an annual basis to go back and look at them, because the landscape in DEI is changing. The public opinion around it is changing. And while you may not be saying anything that's unlawful, or, if you're legally challenged, would find to be unlawful, but it could strain the organization's reputation or misconstrue what you're actually thinking or believing or doing. Another practical strategy, Cara mentioned that our clients, are looking to, recruiting. We want to diversify our workforce, and often that starts with sometimes just diversifying the pool of applicants. And I ask clients, have you looked at your job postings that you put out there? Oh, I have a different slide.
You want to do this one and I'll do that one?
Yes.
Okay.
Yeah. So I was like, so I often, start with look at your job postings. A lot of people don't look at, the job title, description, requirements, and how they post externally, but it's good to look at that, because tweaking that can certainly help diversify your pool of applicants. Most women or minority candidates, even if they feel like they can do a job, but if they don't meet all the requirements, won't even apply. Where conversely, white men, even if they don't meet all the requirements, will apply. So if, say, education is not a minimum requirement, or there is a specific other requirement, a physical requirement, or something that's not really necessary, take it out. It might actually expand the pool of applicants that you get. Also,
I have a good example on that one too,
Yeah.
Punam. When it comes to the minimum requirements, I had a case come up a couple of years ago, and the employer really typically did a really good job about updating their minimum requirements, but one kind of unfortunately was not caught, and it was it required the ability to drive and to have a driver's license. And they actually had a complaint filed by a blind candidate who they couldn't drive. They didn't have a driver's license, but there were lots of other means and modes of transportation in that geographic area. And so he challenged that as a minimum requirement, and the company had meant to change it. So, it wasn't a problem to do that, but it was a good reminder, things we don't always think about, because they've been in our job descriptions forever. And we're just not necessarily thinking about, the logistics or practicalities of things. So, and I think that's a good example of, again, it's not just about race and gender, but there are all kinds of ways we can try to make them more inclusive, especially for individuals with a disability.
Yeah. Well, I'll turn it over to you. I mean, I think the only last point that I was going to make is that, there's research that shows that millennials and Gen Zers, who are the biggest employee pool out there, like to see DEI, want to see companies have DEI policy or EEO policy or some equity policy in their job, posting. So I always say it's a good idea to put that out there if you have it in the job postings.
Yeah, I agree. The studies show that that's a very important factor for millennials and Gen Z when it comes to them making an employment decision on where to go to work. So definitely. Another suggestion, if your systems or processes will allow it, is to conceal applicant names from decision makers, at least early on in the process. There are lots of studies that show applicants with racial or ethnic sounding names, they're just less likely to get hired. And so if we can kind of remove some of the potential initial barriers and get them all further along in the process. Again, I know Punam mentioned earlier kind of unconscious biases, and we all have them, and this is maybe a way to help combat that, and get individuals through the process a little bit further. So if you have that capability, it's certainly something to consider. Another important piece of your process is to be analyzing your selection practices. You need to know if there's something that's having an adverse impact, especially on the basis of race or gender. So if you have applicant data, you can compare that to the hires that you've made to see if one group is being statistically significantly adversely effective. So if we're selecting men at a much higher rate than we're selecting women for a particular job, doesn't mean necessarily that discrimination occurred, but it would certainly give you a reason to research that area. What's causing this? Is there some barrier or impediment that we're not aware of that might be limiting the opportunities for women in this role? So definitely do those types of evaluations. You can also look at your separations. Do we have one group that's leaving our workforce at a higher rate than others? And if so, why? Again, people leave an organization for lots of different reasons. It wouldn't necessarily mean that there's a problem, but if we do, for example, show, like for Punam's example at the beginning, if we have Indians or a certain nationality or ethnic group leaving the workforce at a higher rate than others, then I think it's something to explore and investigate. And we also recommend that you take any internal complaints about your DEI policies seriously. We can't assume that if just because someone, they might be alleging reverse discrimination, we can't assume that we don't need to take that just as seriously as we would take any other type of discrimination complaint or concern. So if someone raises a concern about our DEI policy, we want to make sure we look at it just like we would any other type of complaint, not necessarily just, disregard it or consider it as not something that's important for the organization to consider. We've seen lawsuits, some challenges within the past couple of years on this very issue. There was a case, I think it was out of California, where an HR individual raised concerns about the employer's, it was like a leadership training program for women, and the HR individual raised concerns that it was discriminatory. And the quote from the complaint was, she was told by her supervisor, "This is the direction the world is going, so either get on the train or get run over." And so, I don't recall if she was terminated or alleges constructive discharge, but she certainly raised a retaliation complaint based on her raising the concern about the program. And then we also wanted to remind you about supplier diversity programs. These can also raise concerns. It's, I think, fine to make sure we want to have a diverse pool of suppliers from which we are choosing to do business with. But just remember that Section 1981 does prohibit the use of race in making contracts. And this is actually the law that we are seeing a lot of challenges being raised, or using that law when it comes to grant funding or fellowships, things like that. If so, even if there's circumstances where Title VII might not apply, Section 1981 could. So be mindful of that. Before we end, we've got a few more minutes, so we'll do real quick some 5 key takeaways for you, and then we will look at questions. I know we have a couple in the chat, so we'll do these and then finish up with questions.
Sure, great. So 5 key takeaways. I always say number one, like literally number one, look at your DEI policies and practices, whether you do a formal audit, review, or privileged one with your counsel. You know, the legal landscape's changing, the political views on DEI are changing. And so what may have been okay or non-controversial a few years ago may not be best practice today. So it's always a good idea to do this. And I always say, leverage your DEI data that you likely are already collecting. If you're an employer over 100 employees, you're putting together demographic data of your workforce. Leverage it to measure how your programs are working. Like Cara said, you know, analytics are really important. If you're seeing trends, it's always good to investigate and then create your DEI policies around how to correct. And it also could be defensible if you are legally challenged. Again, DEI communication seems to be the big thing. It's the thing that's out there that we're seeing folks hone in on, you know, both people who are for DEI and who are against DEI. So make sure you look at what your communication looks like, not just internally, not just on your website, but, you know, in all kinds of media, whether it's for your customers in marketing materials, whether, you know, like us law firms, you know, when we do an RFP, you know, revisiting it, making sure, you know, we're reporting accurate DEI data, we're reporting accurate information that is tied in, again, to the values and principles that we are looking to create a better workforce culture. And, you know, it's again, data here is very important in how you couch it. Like Cara mentioned, it's probably not a good idea to put specifics in all of these mediums, more about equity and fairness and your kind of broader macro level principles.
And training managers and supervisors, we've touched on this, but it is really important to have the individuals that you are empowering as your representatives to, you know, understand the nuances in this area. Unconscious bias training is generally going to be okay. I know there have been some concerns raised about it, but all the ones I've seen, I think are very acceptable and wouldn't raise any problem. And it's important for all of us to understand that we do come with those biases. We want to also make sure we're training our managers about what it is acceptable to say and what's not acceptable to say. You know, because terminology is changing all the time, and I don't necessarily like the term politically correct, but that's really what we're speaking about here. Terms come into you know, what's acceptable and what's not acceptable. That's changing all the time. So it's important for our managers to stay on top of that as well. So we need to make sure that they understand that. Also, interview questions. That's super important that they know what they can ask and what not to ask, or to suggest to candidates. We still see areas where managers get tripped up by that. And, you know, sometimes it's just in the chit chat part of the interview, but it can still create a problem if it creates a perception that the manager or the decision maker might be using an impermissible criteria for the selection process. We've already talked about this, analyzing your selection processes for adverse impact. We can't emphasize it enough. So definitely, you know, if you've got the data, and for most employers, you should, you can do a privileged audit of your employment practices to see if there are any areas of concern, and then, you know, develop an action plan should there be data or results that are not explainable.
So we'll conclude here by saying, DEI, the goal here is to make sure all employees feel that their workplace is fair, equitable, respectful, despite our individual differences, right? That is kind of at a macro level, at the most simplistic level, what we're all looking to achieve. And when we do that, that sense of belonging that we all want in our workplace, we know it works. And when it works, lots of good stuff happens. I was just reading a study by Paradigm Strategy, which I can actually add to the chat if I can find it quickly, or we'll definitely, when we send out the materials, we'll provide this. But it's a report called Unlocking the Potential of Your Workforce, the Benefits of Belonging. And just briefly, they studied 38,000 employees over 53 organizations. And key highlights is that when they found a strong sense of belonging with these with the employees and their workforce, they found that these employees were 10 times more likely to be engaged, 7 times more likely to feel respected, 5 times more likely to feel psychologically safe at work, 14 times more likely to feel confident in the organization's decisions. And that last piece to me, and there's a whole bunch of other benefits, but that last piece to me is significant, because if your current workforce trusts your leadership and the company's decisions, and they understand that they're drawn from the company's values and principles and they're aligned with it, they're more likely to support your DEI efforts. So I'll leave it here, see if there's any questions, or if Cara, you want to add anything.
No, I think that's
Very
great.
close.
We'll switch to, I know people are waiting for the SHRM credit, so we'll put that up there. And HRCI, we did have one question over here. Let me get to the chat. So the question is, we have a woman and allies group that will be rolling out in the next few months. So talking about ERGs, their council guidelines limit the number of allies to 2. Could the limit on allies be an issue? That's a really good question. So like Punam said at the very beginning, the devil is in the details. So I don't necessarily want to say, yay or nay. We want to dig in a little bit and look at the architecture for your ERGs. But I would definitely want to look at that more closely, because what we're saying, I think, is, so it's women and allies, but only 2. So that means we'd only let like 2 men in, I think, if I'm interpreting that correctly. So we're excluding all other men from the group. I'm assuming that's what that means. So I would have maybe a little bit of concern about that. But again, it's going to depend on what are the ERGs, how are they set up, what's the function, what's the purpose. So we'd want to look at it in more detail, but at first blush, something to, I think, investigate a little bit more.
Yeah, I looked at it a little differently. I thought, meaning women and allies, like 2 other types of allies, like maybe men and
Oh, yeah. Okay.
some other, whether it's protected, diverse class or not. So again, like Cara said, it's devils in
We
the
need more
detail.
information.
Yeah, I think we'd have to look at what the guidelines say and why the limit is 2. Maybe there's some justification. So I don't see any other questions, and we're
Yeah.
just about at time. So thank you everyone for joining us this afternoon. And if you have any questions that come up after, we end today, feel free to reach out to Cara and I, and we'll be happy to talk to you.
Absolutely. Thank you so much for joining us. We'll sign off, and in the recording, which you will get probably tomorrow, Victoria will send around the slides as well as the recording. So thank you so much.